that precedence or addendum to the precedence investigation report?
Have, Your Honor.
We have, Your Honor.
All right. And Mr. Martineau, can you hear the court?
Yes, I can. Yes, Your Honor.
All right. We're going to have to turn you up a little bit because you came in very quietly. Mr. Martineau, would you confirm again whether you have had an opportunity to review the APSI?
Yes, Your Honor, I have.
Thank you. And are there any corrections or factual inaccuracies in regards to that APSI, Mr. May, that you're aware of?
I'm not aware of it. My client hasn't let me know if there was one or not. So.
All right. And Mr. Martineau, have you, was there anything in that APSI that you believe to be incorrect or factually in error?
No, Your Honor, it was correct.
All right. I would note that in this case, as I've stated, Mr. Martineau is appearing via Zoom. However, I believe that a couple of other individuals are appearing via Zoom. Just one moment. There is a Penny appearing via Zoom, as well as a Case or Casey Johnson, who I believe are victims in this matter and certainly have a right to be present for this hearing. And are there, Mr. McKenzie, any other individuals who would be considered victims under the statute that should be present or wish to be present that you're familiar with?
Not that I'm aware of, but I don't know who is on Zoom. The screens aren't on, so I can't tell who is on. And the only other victim would be a Brian Martineau. We've advised him. I was aware that Penny and Casey were going to appear by Zoom. I've not heard anything from Brian, so I don't know if he is on Zoom, but I know he was made aware of the hearing.
And he is not. And unfortunately, we've had technical issues where we cannot get the TVs to connect. So we have been working on that, but unfortunately, you're going to only be able to hear people today. I truly do hope that we can get this situation fixed sooner than later.
It would be good.
But I can see Mr. Martineau myself, and he is coming through well. So then, Mr. May, I'll turn to you first for your recommendations.
Yeah, Your Honor. So I know, obviously, this court judge.
That might be a reminder to everybody. Please check your cell phones and make sure that they're off. Mr. May, go ahead.
I guess when the sentencing happened, Your Honor, it was Judge Dunn who was actually the one who sentenced Mr. Martineau in this case, and so obviously you weren't there at the time of the sentencing. But I think to make the court aware, if the court isn't aware of it, that there was another case that happened down in Arizona that was kind of related to these ones. And down there, Mr. Martineau was placed on actually probation out of Arizona and wasn't incarcerated. And through that, I don't know if this court is aware that in Arizona, because of the crimes that he pled guilty to down there, they actually placed him on what is called lifetime supervision. And what that really means is, what my understanding is that he will at least be on 10 years. I mean, that's the soonest that he would be able to be released down in Arizona if, as my understanding, everything goes well. But that is the least amount of time that he would be on probation. So I guess where I'm going with that is that obviously the APSI recommends that he be placed on probation. And that's what I would be asking the court to do today. Obviously, from reviewing that, there are a couple things that I'd like to point out specifically. I think this was a perfect rider that Mr. Martineau did. It explains here, Mr. Martineau did not receive any disciplinary action showing that he could follow the rules of the institution, meaning that he had no sometimes they have some disciplinary smaller things that happen while they're up on a rider program. He didn't have one. Also, Your Honor, I didn't get from him because it was a little bit difficult to get in contact with him, but he does have certificates that he wanted to make the court aware that he completed all of his programming out of there, and he actually did receive his GED. In the rider, I think in the APSI, it says that he was going to complete these programs as of 8/20, but it's my understanding that he completed all of them prior to the rider review hearing, and so he has those certificates. And Mr. Marno can probably explain to you a little bit better with that. The other thing is, Your Honor, is just to read from here, which I think is, why he excelled, was Mr. Marno has been an excellent group participant. He sets a high standard of meeting of all expectations. He personalizes his work and does quality role plays. And based on the encouraging pattern of behavior, it is expected that he will complete the high-quality success plan to help him in the community, and he appears to have reduced his risk to reoffend. I think, Your Honor, those are coming from as to the recommendation as why he should be placed on probation. I guess this is what I'm saying is because he's going to be put on lifetime probation, or he is on lifetime probation out of Arizona, they're going to be supervising him. And I guess not that I understand that the court would be concerned and need to put him on probation, but I guess the question is, do you need to put him on supervised probation out of Idaho? Meaning, you put him on probation with an unsupervised, lower level type of supervision, meaning that then Arizona is really the ones that are going to be doing the supervised probation out of Arizona. And the reason why I'm saying that is because you have and even if the court wanted to put him on 10 years of unsupervised type of probation while Arizona is doing this, it's just that then he has one probation officer out of one place where it doesn't get confusing with regarding terms and conditions and what he's supposed to be doing, meaning giving him a real chance to actually succeed, where it doesn't get a little bit confusing out of that. Because one of the other problems that he's facing is the housing right now. He does have a job out of Utah. He kept his job from his prior employment when he got put on the rider program and he was incarcerated, but his boss held his job out of there. And he's trying to work to be able to interstate compact down there so that he can keep his job. And it's a very good job, well-paying job.
Where's that job?
It's out of Salt Lake.
Okay.
It's called Global. It's right there in the APSI.
No, that's fine. And I saw that in the APSI. I just didn't know.
Yeah.
I thought it was here in Idaho.
No, so it's actually out of Utah. His family, he actually lives in Utah. His wife and his kids they live in Utah. When he was arrested on this case, it was out of Utah, and then they brought him up here to Idaho. Same with in Arizona, as to how that was. But I guess with regards to that, the reason why I'm asking for that is because then I think it would be easier for him to, one, be successful. Not trying to make it lighter than what needs to be. I get that these crimes they were bad, but I think he's done well on his rider. He's done his treatment programming that we would want him to do out of the rider program. He got his certificates. He's passed everything. He's going to be having to do sex offender treatment programming out of Arizona. And so I think the court, if you have concerns, I think your concerns will be softened due to the fact that he's being supervised out of Arizona. There's going to be somebody watching him. He's going to be having to do all the programming. And actually, I think Arizona is a little bit stricter than Idaho with regards to some of the terms and conditions that he's required to have to do. Right now, the housing issue is a problem because even Arizona won't even let him move back into his own house where his own kids are, to be around minor kids, his own children.
So is he on the sex offender management out of Arizona then?
Mm-hmm.
Okay.
He's going to be out of the sex offender registry. He's out of management program. He's going to be required to do all of the things that you would require him to do if he was unsupervised, and then some, out of Arizona. And so I guess that's where I'm kind of asking with the court, if the court if you wanted to put him on 10 years of unsupervised, but if not, then I would say if you do supervision, 5 years would be sufficient enough. He's going to be on 10 years. And so I think, but, so it's not confusing, you know, and you have one type of probation dealing with one probation officer out of one state. I think that would make it easier and a better success for him. And that's what I would ask for the court to do. Thank you.
Mr. McKenzie, or actually, let me, before I turn to you, Mr. Martineau, is there anything that you'd like to say on your own behalf?
Yes, Your Honor, I would. I wrote it down if it's okay for me to read it.
Just one moment. You wrote what?
I just wrote a statement if I could read it.
I wish I would have.
Oh yes, please do. I was going to say I've not received a statement other than what was provided in the APSI, but yes, if you have a statement you'd like to read, please do.
Thank you, Your Honor. This program at this facility has greatly improved my life, mostly in how I think. From the school where I was able to obtain my GED to the several 12-step programs available. I was also able to be involved in the mentor program, which is an honor system here at Cottonwood. But most of all, it was the cognitive behavioral intervention for sexual offending program that was most beneficial to me. I learned how past events and lifestyles shaped my life today, and how I can shape my future for the better by making the best choices now. And also, and most importantly, I have learned the skills to make the right choices when faced with risky situations so I don't reoffend. I believe this program is a blessing and a privilege, and I thank all who was involved to make this happen, from sentencing to this hearing. And thank you, Your Honor, for let me give my statement.
Thank you. Mr. McKenzie.
Thank you, Your Honor. The position with regards to the state, the court follows the recommendation of the APSI with regards to placing the defendant on probation. The state does not agree with the argument that probation should be unsupervised. This was an egregious case. The defendant had victims, multiple victims, and charges in 3 different states. The plea agreement that was ultimately reached was a plea agreement that was a global agreement that resolved all of the possible charges, the charges that were pending, and the charges that were going to be filed in, I believe it was Weber County down in Utah. The argument that he'll have multiple probation officers, I disagree with that argument. The fact of the matter is he's going to interstate compact. If he's placed on probation here, there will be an interstate compact, which he'll do down in Utah. He'll get a probation officer that will be supervising him in Utah on the Idaho case, and the very same thing is going to happen with Arizona. We're not dealing with a situation where he's going to have multiple different probation officers. He will have the requirements of probation, but I think in light of the circumstances and the charges in this case, he should be required to comply with the sex offender treatment requirements for Idaho as well as Arizona. A lot of them will be the same or similar. Arizona may have some additional ones that we're going to require him to do. Idaho may be the same. But that's the nature of his charge. That's the nature and the consequence of his action. From the perspective of the state, an unsupervised probation, I'd object to doing that. He should be placed on supervised probation. He has an underlying sentence of 20 years on the charges that he pled guilty to here. Again, that's the nature and the seriousness of the charge. He'll interstate compact. It's not going to have a scenario where he's reporting to 3 different probation officers. He'll have one probation officer wherever he winds up, and he'll have to comply with the terms of probation of Idaho and also of Arizona.
So did the judge approve the interstate?
The state's recommendation at this point in time is that he be placed on probation. that be supervised probation. He can interstate compact, and if he chooses to do that, I would expect Utah will probably do that. But as far as an unsupervised probation, based on the nature of the charge, I think that would be improper. So our recommendation is, pursuant to the APSI, that the court follow that recommendation, that he be placed on probation, but it be a supervised probation. He can interstate compact to Utah, and then comply with the requirements of sex offender probation in Idaho as well as in Arizona. The agreement between Idaho, Arizona, the defendant in Utah, they were all interrelated, and it was a global resolution with regards to all three states. So with those things in mind, that would be our recommendation, Your Honor.
Okay. Any further rebuttal from the defense?
I guess, Your Honor, just the situation right now, the court needs to know he hasn't been approved yet to interstate compact out of Idaho to
He's
Utah.
actually been denied.
And so he's actually going to, I think the APSI even says in housing that he's going to have to be getting a hotel down here to be able to stay for a period of time because Utah hasn't accepted them.
That's funny. I wonder what
because
hotel
of
he'll
the
go
housing
to.
issue that they're trying to figure out because of just what I mentioned before. They're not letting him stay in his actual residential house because there's minor kids that are in there, even though they have nothing to do with any of this. And for some reason, Arizona, that's one of the stricter requirements because of their programming. I mean, I guess the thing is I guess the question is, why beat a dead horse? Meaning you have supervision. The court knows that there's going to be supervision. He's going to be supervised one way or another. I don't know why we would heap more restrictions or certain things on him when we want him to be successful on probation when he's going to have that supervision already anyways. And the reason why I recommended unsupervised is because then you can continue, even though you don't have a probation officer over his head, you do have probation there. If he violates or commits another crime, he's going to still be facing his sentence that would be hanging over his head, meaning that you would still have the punishment component that would not go away. There's no reason to have double payments, costs. All of that would be heaped onto him because he's going to be on supervised probation out of Idaho and both out of Arizona, where I don't think that, because of how well he did, I think he should have reduced some of the concerns for this court due to the fact of how well he did up on his writer program. The case, Your Honor, also you have to understand that these crimes were done a long time ago. Obviously I know they were done a long time ago, but he also had polygraphing and stuff like that, and he passed that, showing that there was no other types of
And the judge actually said that he was a psycho for being able to pass that.
From that time period. And so, and he actually passed his polygraph altogether. But, so I don't think the court is concerned that there were other victims or things that happened in between from that time, meaning if the offense was back however long ago, it was like 20 years ago when this occurred. And so he got treatment then, he got treatment now.
He did not get treatment then.
I just think it would be appropriate for the court to do that. And that's what
Thank you. Mr. May, is there any legal reason the court should not proceed with disposition here? All right. Then, Mr. Martineau, I'll just state for the record, I have had an opportunity to review the APSI, as well as the underlying pre-sentence investigation report, and the psychosexual evaluation, the polygraph that was done with that, that was attached to that pre-sentence investigation report. I am familiar with the facts and circumstances in this case. I've also had an opportunity to review the plea agreement that had been entered into. I would note that it's a binding plea agreement that Judge Dunn had bound this court to, finding that if a rider recommendation was made by the pre-sentence investigation report, that the court would concur with that rider recommendation. And I've had an opportunity to review that. I have actually given this case a great deal of thought and consideration as to what the appropriate outcome should be here. Now, at the same time, I was also not the judge taking a change of plea, nor was I the judge binding myself to this plea agreement. And I recognize that I do not have even the advantage of having the same information that that judge had at that time, nor hearing the same argument at that time in relation to that plea agreement. And so I cannot naturally say whether the disposition in this case was improper, in that I recognize that Judge Dunn likely considered many things, to include the 4 factors of criminal justice that I am bound to consider today. And those are being protection of society being the primary factor, with rehabilitation, deterrent, and punishment also being factors that this court must consider at sentencing. This court should also consider first as to whether supervision in the community is appropriate, and truly should default to that option if that isn't the appropriate option for a person. Now, at the same time, so when I look at this case, it is a very serious matter. You have been found guilty of 2 very serious felony offenses, that being sexual abuse of a child by having sexual contact with a minor under 16 years old. In this case, fairly young individuals. Both of these offenses are punishable by up to 25 years in prison. I can see that Judge Dunn found that these offenses were serious in their nature, and that he imposed 10 years fixed as an underlying sentence. I would first congratulate you on a rider well served. Mr. May put it well that there's nothing in there that indicated that you did a poor rider, that you had no disciplinary actions, you took and engaged in the treatments as required, and I applaud you for that. That certainly is something this court takes into consideration. I do think you're amenable to treatment. Likewise, the fact that there has been approximately 30 years since these offenses indicates to me that in many ways you have changed from the person who committed these offenses. In review of the psychosexual evaluation, it's indicative of a person who is of low risk, at least, when it comes to offense. And so when the court considers the factor of rehabilitation, I think that that is to the benefit of yourself in regards to probation and your willingness to abide and follow the rules of probation. I actually do not think that you're a bad candidate for probation in that aspect. Then there's the other part of this case that this court must consider. And ultimately, as this court already stated, the offenses you committed are very serious offenses. Though they were done 30 years ago, they're serious offenses. Inevitably, this court always has to weigh, sometimes, well, in all cases, justice and mercy, what is right, what is needed to protect society, or to deter, or to punish. And that's part of the place where this court gets hung up. Because although you may be a very good candidate for probation, has those other factors of sentencing been met? In regard to protection of society, I don't find that to be a terribly, even though it's the highest here, I don't see that the information, other than the actual offenses back almost 30 years ago, indicate that you're a great threat to society. And that weighs to your benefit as well. The things that do not weigh to your benefit is there should be a punitive, or in many cases a punitive factor to offenses of this seriousness. I'm going to pause here again. Ladies and gentlemen, it's okay if you pull out your phone, look, and make sure it's on silent. Please do so. I don't mind if you pull it out right now to look. If you don't know if it's on silent, please put it on silent.
Somebody else's phone wants to ring. I like this, Judge.
So there is a punitive factor that often comes, and one of the reasons for that punitive factor is by the statute itself and the case law. Sometimes it's just simple retribution, that some people, for some offenses, need to be punished for their conduct. The other factor is deterrence. Not just deterrence of a person, but deterrence of society. That society knows that there are certain crimes, particularly, that come with consequences. And that it's those consequences that shape, sometimes even inadvertently, public behavior and what we determine to be appropriate or not appropriate. And the court takes that seriously as well, minimizing the seriousness of these offenses and whether that should be proper or not. Now, I have considered, under Idaho law, this court certainly can not give you probation. However, it is important to me that people's constitutional rights are protected. I would note that under this plea agreement, it was binding upon this court. It was indicative, at least in the record, that a rider would be followed by probation. I do believe that was your belief when going on a rider. I believe that's why you did a good rider. But more, I'm sorry, who was that?
He's gonna make them leave.
Hey, ma'am. I believe that was your thought, and that was your consideration when you waived your constitutional right to a jury trial. And that's important to this court. And I will not be part, certainly, of taking somebody's or depriving somebody of a constitutional right. And so I will be bound to that. I am going to be providing you with probation. I do believe that you have certainly shown yourself amenable to treatment, shown yourself to likely not be a risk, at least within your most recent behavior and your engagement in this program. I do recognize that riders are not meant to be punitive in nature. They're meant to be rehabilitative in nature. But because of their very nature, it happens anyway. There was still a punitive factor here in serving your rider, that you still had to spend time incarcerated outside of the community. You lost your right to freedom. And that acts as a punitive and deterrent effect. And I recognize that as well. So as the court considers what to do here, I have to look at all these factors in determining what that probation should look like. I am concerned about, I understand the requests of your counsel in regards to unsupervised probation. That I don't know is, well, I don't believe is the appropriate option. And one of the biggest reasons is, first, I do not intend to make the state or my clerks into probation officers. you will be given certain terms of your probation that will need to be monitored. And I do not want them having to fill that responsibility. And though the monitoring will happen by another probation officer down in Utah, if you do get the interstate compact, that any violations of those probations will still have back here. And the person here would need to make a determination and file a probation violation if that occurred. I do not want that to have to be somebody that is not of probation. Likewise, I know that there are certain conversations that can happen between an interstate compact probation officer and the state where they come from, where they make determinations as to whether probation violations are issued. And so first of all, do not think unsupervised probation is appropriate for that. The other reason is I truly am not certain that an interstate compact is legally with an unsupervised probation. This is an issue I've never looked into, and I'm honestly not certain as to the intricacies of that. And so it's not a great consideration of the court, but the court is left with that concern. Either way, though, the offense itself constitutes one that I recognize that this is a burden on you, or a potentially greater burden on you. It is not an undeserved or unburden. There is, regardless of how we think about it, some punitive nature behind probation. And whether that comes in the aspect of fines and fees, or just simply having to check in, or having somebody over your head, the court considers this also, not just a supervisory measure, but in part a punitive one that I think is appropriate for both reasons. And so I'm going to require that you serve supervised probation in this matter. I recognize that you've been placed on lifetime probation with a mandatory minimum of 10 years. I do not know what Arizona intends to do. You've been given a 20-year sentence here in Idaho. Underlying sentence, potential sentence. And at least my understanding then would be that potentially a lifetime of probation down there, depending on how things go. I recognize too that this court has allowed people early release from probation. In fact, I would state that the interstate compact individuals generally even have a sooner request from probation for early release than even is the matter of practice here in Idaho, particularly when the interstate compact is from Utah. And so it certainly, whatever term this court imposes, the court recognizes that it may not be what you ultimately serve depending on how well you do on probation or depending on the probation officer's concerns. And so the court will actually be imposing 20 years of probation in this case. That would be consecutive with the 20 years of underlying sentence that you received, and it will put you into your 70s.
Sorry, Your Honor, did you say consecutive or concurrent?
Concurrent.
I think you said consecutive, sorry.
Oh, sorry. Concurrent.
Concurrent, okay.
And I didn't even mean either word. It is reflective of the 20 years.
Yeah.
Thank you for catching that, because that could be a very serious legal issue.
Consecutive on top of that, but.
Yeah, no. So 20 years total. And with the understanding that if you are done in 10 years because Arizona and they're recommending it, this court will consider potentially at that time, depending on the facts and circumstances, letting you off early. But at this point, that is what the court's going to be doing, particularly given the nature of the underlying offense and the need for sometimes just full supervision, even if it's just somebody watching. Knowing that that is occurring can be a deterrent factor for individuals, and given the underlying conduct, deterrence is an important factor here. I will require the recommendations of the pre-sentence investigation, or the psychosexual evaluation, which recommended sex offender treatment. It recommends that you do so outside of high-risk individuals. I will certainly encourage probation to allow you to take a sex offender program where you can meet those. But what I'm going to do is recommend or require the treatments recommended in the psychosexual evaluation, as that person has determined that that is needed. And so that will be a term and condition of probation if you accept probation. I will also order 180 days discretionary time that the probation officer may impose in their discretion pursuant to the Idaho rules. One of the things that I noticed here is that you have provided an agreement of supervision. However, it appears to be just the standard agreement of supervision. Ms. Hatch, is there a separate agreement of supervision for sex offender management? Okay, I believe that there was. First, I'm going to go over this agreement of supervision. In here, and it's the sex offender one?
Ron, I think he did sign.
Oh, I do see it. I just had not flagged it. I tried to put the things up on top, and I missed that one.
Yeah, you did.
Thank you. I appreciate that. So I see that you have filled out both the IDOC agreement of supervision and the sex offender supervision agreement. I see that these have been initialed and signed. Mr. Martineau, are those your signatures and initials?
Yes.
Did you have sufficient time to go over the agreement before signing these?
Yes, Your Honor.
Do you understand that if you get probation in this case, that you'll be required to abide to the conditions within both of these agreements?
Yes, Your Honor.
This guy wasn't the judge.
Do you have any questions about the conditions that will be required of you under both of these agreements?
Nothing would have flown that did.
Did you have an
The other
opportunity
judge
to
was a
ask
good judge,
of your
but-
attorney any questions you may have had in regards to any of these conditions, if needed?
Yes, Your Honor.
All right. Do you understand that if the court grants you supervision, community supervision and probation, that you'll be required to abide by the rules of sex offender management, which may restrict who you may be around? It may require maintenance polygraphs. It may require other things in regards to digital media or other restrictions on your freedoms. Do you understand that?
Yes, Your Honor.
Do you understand that your person or your property, and even your electronics, phone, computers, tablets, other electronic devices may be searched at the discretion of probation?
Yes, Your Honor.
Okay. I will require, this is required by law anyway, that you register as pursuant to the statute, and that you abide by the terms and conditions of these, both of these agreements of supervision. And that will be a requirement of probation in this case. I will order a fine of $1,000, and that will be per count, for a total of $2,000. I will order court costs in this case in the amount of, as set forth by statute on each count. I will also order that you make payments towards the costs of your supervision, and those payments will be in the amount of $75 per month. This leads me, Mr. Martineau, to the most difficult term of condition of probation this court is going to require of you, if you accept these terms. Mr. Martineau, probation is an agreement. It's an agreement between you and the court. that you're going to abide by certain things. And this court can impose certain measures to ensure proper supervision, deterrence, protection of society, and sometimes, as I've already stated, there are punitive measures to probation as well. And I've given this case a great deal of thought. I am concerned that simply placing you on probation with the terms outlined herein is not sufficiently deterrent to society or to yourself. I think it minimizes the gravity of the criminal conduct that you did. I think it largely ignores the punitive factor when it comes to your conduct. And so though I am willing to place you on probation, you will only be granted this option if you also abide by the following. I'm going to require that in addition to the time that you spent on the rider program, which you will get time served for, that you also serve an additional term of incarceration in the county jail of 1 year. And that will begin today. And that is meant purely for the purposes of punishment and deterrence, so that the community may know that this conduct is unacceptable. Mr. Martineau, that will be a term and condition of your probation, that you serve that time. Are you willing to accept probation on these terms?
Yes, Your Honor.
Okay. Then that will be the court's order. I will order that you complete probation. You will be released from the custody of IDOC and turned over to the custody of the Caribou or the Bear Lake County Sheriff to serve that additional time as a term and condition of your probation. After which you will begin your probation. The payment fees will begin. I will give you 2 months after your release. So you will be released September 5th, 2025, and your payments will begin to be required November 5th, 2025. If you certainly have a right to appeal this court's decision today. You have 42 days in which you may file an appeal. If you cost of the appeal, the cost of an attorney for that appeal, those costs can be afforded. All right, that is the court sentence. Are there any other issues from the parties? Mr. May.
I guess I need to look over the binding Rule 11 agreement, and it's my understanding that part of the binding Rule 11 agreement was there was going to be no incarceration with regards to the requirement of that. And so I guess if the court was saying they were following the binding Rule 11, I'm not sure if that is the case.
Please do. I'd rather deal with that issue today than, if that is the case, then I understand, and I certainly am intending to bind myself to that agreement. So that would be an issue that we'd need to bring up.
So, Your Honor, the way that I read the agreement, and I mean, I guess the court can...
And I'm looking at it now, so if you want to point me to this section.
Just think otherwise. It says the court will be bound to concur with the pre-sentence investigator's recommendation, which would be then that he would be required to go do a retained jurisdiction program. which I think this court also agrees with that. As part of that was if the retained jurisdiction program recommended probation, that was the understanding that what he was going to get out of this if he ended up completing it correctly, meaning he wouldn't be incarcerated again as part of that agreement, meaning following the recommendation, going on a retained jurisdiction, and then if the program came out and said, look, we put you on probation, that's what the court would do.
Okay.
And so I think that was part of the binding Rule 11 agreement as part of this. And so I don't think that it was contemplated that if the retained jurisdiction program came and said, look, yes, he can be incarcerated, I think then at that point the court would then incarcerate him, or would be required to incarcerate him actually. And then if it required him to go do probation, then the court would be bound to put him on probation.
Understand. Mr. McKenzie, any thoughts?
Your Honor, just one thing I would note with reviewing the judgment of conviction, it does appear that Judge Dunn did impose a fine of $500 on each count. The court just imposed $1,000. So I think that portion, I think it's a $500 fine. With regards to the incarceration, I think the court is clear that the incarceration for a year is a term and condition of probation. I don't believe that this is a violation of the plea agreement. He is being given probation, but as a term and condition of his probation, he's being required to serve additional jail time, not prison time, jail time. And oftentimes, courts will impose, when a defendant is placed on probation, will impose additional time to serve. I do not believe, as a term and condition of the probation, as part of the sentence. So I disagree with counsel's interpretation of the plea agreement. I think that the term and condition of probation, that he served the additional year, is within the scope of that plea agreement. I don't think that it's a violation of that plea agreement or outside of it. The court has the ability in any kind of a sentencing when it places a defendant on probation to require additional time to serve. And that's not a violation of what this plea agreement is. He's being given probation, and a term and condition of that probation, as any other term and condition is that he served that jail time. So from the state's position, I think the fine, it should be the $500 fine. That is what Judge Dunn sentenced at the time. But with regards to the jail time, I think that's within the plea agreement. That's part of his probationary terms. And I don't believe that it's a violation of that Rule 11 agreement.
Okay. Well, first of all, Mr. McKenzie, I'm grateful that you brought that up. I apologize. I did recognize that. In fact, it's probably why I didn't write down fines even in my own notes. I will revoke that portion of the sentence in regards to those fines. He had already been sentenced in regards to fines by Judge Dunn, and so I will not add that as part of my judgment, as well as the court costs. I believe Judge Dunn also already ordered, and so that need not be part of my judgment today. As to the issue of the year, in reviewing the pre-sentence investigation, or no, the binding rule agreement, binding Rule 11 plea agreement, it does just state that this court will place Mr. Martineau on a retained jurisdiction program. It does not mention probation, and neither would the court accept one that required probation, because this court does recognize that the courts and the case law has made it very well established that the court, even after a good writer, need not impose probation. Writers do not guarantee a probationary period afterwards. And I've seen the courts even do that before. Sometimes the courts will even send somebody on a writer, not to see if they'll do a good writer, but to see if they'll take accountability for certain things. In fact, I was part of a case where the court did just that, and revoked their relinquishment. The court does not find that you did a poor writer, and the court's binding itself to the plea agreement in that I think the spirit of this plea agreement certainly considered probation. However, I agree that it has been the practice throughout this state that the court can impose certain, even punitive measures in regards to probation, such as community service, that could be a term and condition of that probation. And that's what the court is doing here, not just punitive, but deterrent measures. That the terms and conditions of probation are not just to make sure that compliance is met with the orders of the court, that it too, society sees that there is still certain outcomes of certain behavior, and even probation is one of those. And so I am not convinced that the court has violated the plea agreement. I'm certainly not convinced that the court has violated the law as set forth by the Supreme Court and the appellate court and the statutes in this case. And so I recognize that I would take this as a motion to reconsider.
Well, and one important thing, Your Honor, then, if I would like to just bring up, is that I guess with placing him in incarceration for another year, it's just what I had said. He has this job lined up at Global. His boss held it for him for the time period of 8 months for him to be able to, because that was the time frame that we had talked about. Look, if he did a good rider, he'd get back on probation. And I think you would agree almost probably 99% of the time, if one of these comes out and it says he's going to be put on probation, the courts put him on probation. They don't put him for a year of incarceration. And I disagree that jail is a term and condition of probation. That's the reason why in misdemeanors you either go into incarceration or you get placed on probation. A term and condition of maybe that is to suspend it, put it over your head. If you end up violating, then they could incarcerate you. But to directly put them into term or to jail, that is not a term and condition of probation. That's just putting them in incarceration, right? And that's what you're doing here. You're not doing it as a term and condition of probation. You are incarcerating him. You basically are putting him in 365 days of being incarcerated. I think the court really needs to think about doing that and reconsider that due to the fact that he has a job waiting for him. Arizona had very similar charges. They didn't even put him in a rider. They put him on probation directly. Another state had the exact same charges and didn't even think that he should be incarcerated.
No.
Didn't even think to put him in prison, right? Because they could have. They could have did something outside of Idaho. Our agreement, although it was related to it, it was not global or binding on the Arizona court. That judge was able to do what he wanted to do, and they went in and didn't put him in prison. They didn't even put him in jail, meaning that what they did was just said, look, he's going to go on a rider and he's going to be there for 8 months. That will be sufficient enough to beat the jail time because he's going to be in 8 months in prison, basically, and that's what he was. I think the punitive nature of that got the point across as he went to prison. He went to jail. He lost his freedom. He lost his... Now, if you put him in there, he's going to lose his job. And I just think that if you do this, you're making it almost going to be impossible for him to be able to be successful in life after this, meaning that you get a job like what he has lined up will be almost impossible for him to get because he's going to lose that job. It's a job that he's only making like 6 figures that he'll be able to continue to do, provide for his family, and do that. If he gets incarcerated, he's going to lose that. And to be able to have a felony like on your record to get something is going to be impossible. And because the boss knew him, held the job out for a period of time, but if he knows he's going to be incarcerated for another 365 days, that job is going to be gone.
All right.
I really think you should reconsider your position and place him on probation. And if you want to, put 365 days of jail over his head or something to that extent, or even reduce it to, if you wanted to do a few more months incarcerated, if you want him to come back to county and sit in jail for a couple months, but for 365 days for another year, I think that's excessive.
All right, thank you. And I wanted to allow you to make that record too. I would note, and I'm sure that this is what Mr. McKenzie clearly wanted to say, so I'll go to stand up a couple of times. It did appear to the court that the Arizona court did not impose, actually took into consideration that they would do that if he did the rider program. And that was my understanding. So I disagree with the assertion that they chose not to punish. I think that they did consider that rider program down there, and that is a point well made.
Well, that was the 1 year of incarceration they considered. So they would have done 1 year of jail time from the time, but because
Right, and that's what I'm saying.
Yeah,
they
didn't do that.
consider
They said he was going on a rider. We'll give him that time served, and that will be done, and he'll go on probation.
I understand that. And so I just wanted to clarify that. However, I would disagree that this is not a term and condition of probation. He is avoiding a substantial period of the sentence that was imposed that he earned. And that's the underlying sentence that was imposed. That's the underlying sentence that Judge Dunn found that Mr. Martineau earned from his conduct. And then, after finding that he earned that sentence, determined to give him an option of a rider and potential probation. Now, probation is a grace given that says we are going to withhold an earned sentence if somebody agrees to do other things. And these are the terms and conditions this court has determined that he will have to comply with in order to avoid that 10-year fixed, 10-year indeterminate sentence. And so this court is not imposing the sentence. The court is, in essence, setting forth the terms and conditions that this court will consider in order to place him on probation. He has accepted probation by those terms. You can certainly file a Rule 35 under the rule, and the appellate rights are most certainly appropriate and available to Mr. Martineau. And so that'll be the court's ruling today. Thank you, gentlemen. You may be excused, Mr. May.
Your Honor,
Yes.
is the sheriff's office coming to get Mr. Martineau?
No.
Pardon?
Is the
Wife is
sheriff's
gonna go get
office?
him.
Oh, yes. So I will prepare a transport order for the county sheriff to come and collect Mr. Martineau from the Idaho Department of Corrections once they release him. Thank you.
Thank you.
All right. The court will next take up State of Idaho versus